Many Nigerians haven't recovered from the injustice delivered on the 6th of September by the appeal court justices. If that judgment stands, that means not only will the judges have succeeded in rewriting our constitution and laws, it also means that they have created new policies governing elections in Nigeria. Atiku Abubakar and Peter Obi have signified their interest to appeal the judgment at the Supreme Court. They have until midnight Wednesday to file their appeals. If they do not file their appeals before that day, that means this judgment will become binding on everyone. Now, let's see the likely grounds they will base their appeal on. First, with Atiku Abubakar. As you are aware, Atiku Abubakar is currently in a Chicago District Court, where he's hoping that the judge will order Chicago State University to give him the admission records of Tinubu so that he can be able to present this in evidence at the Supreme Court in Nigeria. This evidence is very, very important. It will be the first time Chicago State University will deny Tinubu's certificate in an official capacity. Not that it wasn't known before. After all, they were the ones that released Tinubu's certificate to a Nigerian lawyer under subpoena. This was last year. So in order to get the proper evidence, the way it is done in court, the maker of the document will have to say that this document does not belong to us. Just like the NYSC did in Enugu Governorship Election Petition Tribunal, where they denied the certificate that Peter Mba submitted to INEC. So this is exactly what Atiku wants to get. Yes, to answer the question that many people have been asking, whether the Supreme Court can admit new evidence. Yes, according to the Supreme Court rules, they can actually admit new evidence. And this new evidence definitely qualifies. What if they reject the evidence? What will happen next? First of all, if they reject the evidence, it will be a huge injustice because it is a constitutional matter. The Constitution says that anyone who forges a certificate stands to be disqualified if it is proven. So technicality should not in any way trump constitutional matter. The court is where people run to get justice. If someone runs to the court and starts pleading with a judge, a case that has to do with life and death, will the judge start asking the person why he came through the front door or the back door or even other procedural errors? Or will the judge go straight to the matter and deliver justice? Once a constitutional matter has been brought to the court, they must make a decision. This is the right thing to do. Forget about what the appeal court justices did. There are judicial precedents to that effect, where the Supreme Court disqualified candidates because of certificate forgery. Saleh versus Abba in 2017 is one example. The Supreme Court never declared them pre-election matters. In any case that the Supreme Court agrees with the appeal court judges that Atiku did not front-load the evidence with his petition, he is likely to plead that the new evidence was gotten after Tinubu's counsel joined issues with him at the appeal court. For those who don't know how it happened, Atiku first pleaded in his petition that Tinubu wasn't qualified at the time he contested the presidential election. As a result of that, he asked the court to disqualify him. In their reply, Tinubu's lawyers asked him to show evidence that he wasn't qualified. Atiku now informed them and the court that he will be bringing the evidence to prove that truly he wasn't qualified at the time he contested the presidential election. As you are all aware, he presented many evidence, including the dual nationality, the Guinean passport, many things he tendered in court. On their own part, Tinubu's lawyers only made vague responses. They tendered purported academic records of Tinubu from Chicago State University, which did not in any way address the certificate forgery. Atiku accused Tinubu of forging the certificate he submitted to INEC. Tinubu's lawyers didn't present any evidence to the contrary to counter the forgery accusation, nothing at all. So Atiku now moved to the US court to get Chicago State University to answer questions, most especially the authenticity of the certificate Tinubu submitted to INEC, which of course they've responded. If you watch the other video, they said that they do not know where he got the certificate from. There's no better evidence than this. If the maker of a document admits that the document is not theirs, that's the end of the matter. It's an acceptance that the document didn't come from them, and if it didn't come from them, it was forged. Unless there are two Chicago State Universities in the world, there's no way the Supreme Court can overlook this. On P2B's side, they will likely challenge the appeal court decision declaring all grounds for Tinubu's disqualification as pre-election matters. In this election cycle, many election petition tribunals have disqualified candidates based on certificate forgery. So it's a precedent. Despite these tribunals being lower courts than the appeal court, we also have precedents by the Supreme Court. So if the Supreme Court agrees with them, of course, that will affect Atiku's case too. Then the Labour Party are most likely to argue and cite Abacha versus Federal Republic of Nigeria, where the Supreme Court declared forfeiture as a crime. And this will alter and affect all the judgments of the appeal court, because they were saying that Tinubu's account committed the crime, not him, that he wasn't convicted. Abacha too wasn't convicted, but he was fined by the federal government. So this will put to rest the issue of the forfeiture, whether they will allow it and say, hey, it doesn't matter. Then in future, anyone with even worse baggages can contest presidential election or governorship election, anything. The Labour Party are also most likely to challenge the declaration by the appeal court that they must call witnesses from all polling units where they are challenging the results. The Electoral Act 2022 is very clear on this. Once certified true copies are tendered by a petitioner in court, they do not need to call oral witnesses to testify. These are one of the perplexing rulings by the appeal court. Despite citing this section of the Electoral Act, they still held that witnesses must be called per polling unit. This is simply judicial abracadabra. It is very obvious why this amendment was made to the Electoral Act. It is to make election disputes easier. It's not practical to call 500 witnesses in an election tribunal, not to talk of thousands. It will not only take more time, in fact, it will be impossible to do because the Presidential Election Petition Tribunal is time-bound. There's a limit on the number of witnesses one can call within the 180-day time frame. So if the judges agree with him that they do not need to call oral witnesses, the next step will be to look at the evidence. Since the Supreme Court agreed that CTCs were tendered, and since certified true copies are exact replicas of originals, that means the 18,000 blurred and unreadable copies that INEC delivered under subpoena will be declared admissible in court. This means that the court will go through the evidence having declared that it is admissible. At this juncture, a mistrial might arise. The Supreme Court will not go through the evidence like the appeal court. Theirs is to look at the issues of law. It's not clear if the Supreme Court can send the matter back to the appeal court because of the time allotted to the tribunal has been exhausted. Let's even assume that it is possible. It means the President of the Court of Appeal must convene a new panel to look at the evidence. Anyway, however they decide, these are the main issues that will change the outcome of the election. If these blurred copies are admitted in evidence, that means the substantial non-compliance by INEC will be proved, which will ultimately lead to a cancellation of the election. Now, let's look at another issue that many people have been asking. Why didn't P2B and Labour Party submit their political party agent copies as evidence in court? We've made this explanation in another video, but for those who didn't see it, in election disputes, priority is given to the INEC copies. After the INEC copies, the next one is police copies. After the police copies, you now talk about the political party copies. So if you are going into an election dispute and you present INEC copies, it is taken that you have won that election dispute. There's no two ways about it. That was why they decided to use INEC copies. And unfortunately, the INEC copies that they demanded were blurred. INEC were expected to replace the blurred copies with the copies they used to conduct the election. Because according to the evidence, certified true copies are supposed to be exact replicas of the original. So the court now said that it is not the fault of INEC, despite knowing that top priority is given to INEC copies. They are the ones that conducted the election. If they tender their copies, it should trump all other copies. So there was no need for them to use party agent copies because the INEC copies were available. Remember the case of Hope Uzodinma, the Imo State governor. When Ihedioha was declared winner of the election by INEC, Hope Uzodinma challenged him that INEC did not count votes from certain areas. What did he bring to court to prove it? He brought police copies. INEC that declared the results did not even bring their own copies to back up what they declared. They conducted elections. They're supposed to tell the court, hey, we did the right thing. Look at the figures. Look at all the evidence. As people who don't have any horse in the race, they are supposed to tender the copies, but they didn't do so. So the only option left for Ihedioha was to produce PDP party agent copies. And going by the priority given to the different result sheets in an election dispute, police copies have more value than party agent copies. This is not in any way validating the judgment of the Supreme Court that returned Hope Uzodinma. It's just a reference so that you can understand why the Labour Party did not present their party agent copies. So we'll be looking forward to how they will file their appeals to beat the deadline and all the new evidence, especially the bombshell from Chicago that Atiku will submit. That's if the court will be able to do everything on time so that he will beat the deadline in Nigeria. Despite the possibility of the Supreme Court doing something different being low, they must still appeal to the Supreme Court so that all these judicial abracadabra and somersault, whatever you want to call it, that they conjured at the appeal court, let the Supreme Court make everything official so that going forward we know that they have altered Nigerian policy on elections, processes to conduct an election, and qualifications for any type of candidate that can contest election, many things. They will change many things in Nigeria going forward. Thanks for watching.